see you face to face again. I've been online, I think, for the last few hearings, so it's a nice luxury to be in the room. Yes, I think there is a possibility. I had signalled AK that would need 30 minutes for each presentation, but then, as you'll see in my evidence in chief, that the issues are very much the same. There's only subtle differences to the two. So I do have two presentations, but what I'm proposing to do is I'll go through the foodstuffs one in a bit more detail, and in the time I can just go straight to the points of difference between those two. So I would signal and hope that we can get through this a bit quicker and we can catch up on some of the time this morning. But I'm in your hands, so there it goes. But I'll indicate that I think we can get this done in about half an hour.
Okay, thank you. That's appreciated.
Yeah. So as you have been accustomed to, I have pulled together a PowerPoint presentation that summarises my evidence in chief and just touches on some of the key points. Just take it through it, and as you have done previously, if you have questions or comments on the slide, please interject. I'm happy to talk through it as we go, or wait till the end if you prefer as well. So what I will cover briefly is just some overall comments, the town centre zone provisions, some other changes, and basically summary and key takeaways based on that. So first of all, looking at the overall comments, what I've got here is just a slide which shows so for foodstuffs, primarily within the town, the proposed town centre zone. There's the New World Kerikeri, which I imagine you'll be familiar with. It's based down the road, it's on the end there. It's sort of marked out in that figure one on the left there is from my evidence in chief and shows you where the store is. What I didn't highlight in there was actually, of course, there is a Woolworths located on the northern side too, the southern side of Kerikeri Township, which is also within, I'm obviously here on behalf of foodstuff, but it would be remiss of me not to acknowledge that there is another supermarket within the town centre zone too. We need both. Yes, so look, overall comments, so some of this I'm going to sound like a bit of a broken record, so I've already presented them to you in front of hearing 14, and we had quite a lengthy back and forward questions, comments, discussion on the centres hierarchy, so I don't propose to draw that back up. I'm just reinforcing that my position is unchanged in that. I don't think that the inclusion of the town centre zone goes far enough. If I was to summarise my evidence in this presentation, I generally support the spatial extent of the town centre zone. I don't think that's wrong. If I was going to put a boundary around a Kerikeri town centre, I would put it in the same location that the reporting officers have recommended. So there's no problem with the spatial extent in my opinion. Really, what I think is the primary focus of it is the provisions, and I did listen in briefly this morning. I understand there is a bit of frustration about the process for the introduction of the provisions. I do touch upon that in my evidence. In particular, I've highlighted that reporting officers, council have used the kind order provisions, and we were only signalled that when the 42-hour report came out 2 weeks before the evidence circulation, was at the 12th of September. And had 2 weeks with the actual provisions themselves. I think that could have been signalled a bit earlier, and probably possibly, I'm not here to talk to you about legal procedural issues, but I think it would have been helpful to have more time to actually consider the provisions. The reason I'm saying that is because, in my opinion, it's quite clear when you look at the provisions, they don't look like they've been really properly scrutinised, with a number of clear errors and inconsistencies, which I'll address further in my presentation. So that's sort of the overall, say, executive summary of what I'm focusing on. Spatial extent is all good in my book. It's the provisions that I primarily have concerns with the town centre zone. So focusing, zeroing in and focusing on the provisions themselves. So council have adopted kind orders provisions. Now, adopted with some amendments. I acknowledge that there are some track change amendments within council's provisions. But there's no actual targeted Section 32 AA assessment that I could see in the evaluation of provisions. There's quite an extensive evaluation of the spatial extent of the town centre zone, but there's not actually an evaluation of provisions. And I think that comes through because there, in my opinion, some quite strange provisions that have jumped in there with no real justification for why they're there. I argue that this is a significant gap in council's assessment and makes understanding the rationale of why things have landed where they are quite difficult. I've sort of based it on my own assessment of them just on face value, but we don't actually have anything from the council on the provisions themselves. Primarily, Section 32 that has been provided to you today is focused really heavily on the spatial extent. Again, I'm going to sound like a broken record here, but I will raise it again. It's in my evidence and I refer back to hearing 14. But the lack of use of nesting tables for key activities, I still consider as a gap. I have observed that on Tuesday, or Monday? Might have been yesterday actually, hearing 17, section 42A was released, which is the clean up miscellaneous plan topic. I did observe there's a continued recommendation from council to reject nesting tables. I looked at that and it seemed to me the primary justification given was it's going to be too difficult to do that at this stage in the process. I would argue that that's not a really good justification. If it's a good idea to include nesting tables, which I certainly think they are, then saying that it's too difficult to do this at the stage of the process isn't really sufficient justification in my mind in terms of efficiency and effectiveness. I think nesting tables were incredibly useful, and a lot of the issues that I'm raising in this evidence and in previous evidence relates back to that. And I think nesting tables in a plan where you are shifting from a primarily effects-based plan, as the operative farm plan is primarily effects-based, to a sort of hybrid with a lot of activity-based rules. It's really important that your definitions are correct and you have a very clear link through the effectiveness of policy. So I don't plan to harp on any more about that because we've had quite a lengthy discussion, but just reaffirming my position on that.
I was about to say, has anything changed since hearing 14 in that regard?
No, in fact, I think my evidence and provisions demonstrate the issues again that pop up. So those, and I do have a copy of the, I referred to you in my previous hearing 14 presentation, referred to the Whangai District Plan. What I do have as a separate document is actually the section which deals with that, because there are 5 key definitions which are subject to nesting tables. So industrial activity, commercial activity, rural, this can test my memory, rural production activity, communal, I think, community facilities, place assembly as well. So there's one other one I'm missing here, but I think you get a sense, and it's very clear for everybody, if you refer to a commercial activity within an objective and policy, it therefore nests and includes, for instance, a supermarket. So it includes food and beverage. And it's very clear if you use that more general term in that objective and policy, it then flows down to mean that all those activities that are defined here are included. So in my mind, it's an incredibly helpful tool for interpretation and understanding and application of the plan. And I don't think the justification, in essence, of saying it's too hard to put it in now really stands up in terms of section 32. Moving on, one of the things is the objectives and policies for the town centre zone. I have got the provisions separately, but in essence, I've summarised it in my evidence. They quite clearly anticipate and provide for commercial activities, as you would expect, in my opinion, in a town centre zone. It's a centre of commerce, vibrancy. You want to encourage commercial growth. And the reason I've highlighted that is, I've made the point here, which will go on to the next slide. So this is this argument I made about if you're not going to have a nesting table to include commercial activities, include supermarkets, then you're going to get a situation, well, for clarity, I'm going to say I want commercial activities to say including supermarkets. I think it's much more efficient and effective to do that plan-wide for consistency in a nesting table or a definition. So it's clearly, and the reason I've recommended this change here is because a similar change was accepted, recommended by the reporting officer for hearing 14 in terms of mixed use zone. So essentially the point I'm saying here is, well, if you don't include the nesting tables, then for clarity, we want to know that commercial activity includes a supermarket. That's why I recommend it there. But I think it's...
So my question was, this is consistent with the relief?
It is. But I would still argue that a broader look at this across the board is much more efficient and effective, and it's going to end up with a plan which is much more user-friendly and clear in its interpretation and consistent application. Just moving into the rules. So we have, so what I've got here is I've sort of summarised the issue and recommendation, and I've got on the next slide, I've actually got wording. So I'll sort of talk to this and then I'll take you to the specific wording as I've recommended in my evidence in chief. So this is the rule for new buildings and structures, TCZ Rule 1. I consider that permitted standard 1 unnecessarily restricts alterations that do not alter the building footprint. So what I've said here, suggested here, is that if we should make a similar change to be consistent with the mixed use zone rule relating to where the footprint is increased. And you'll see that on the next slide. There's also a second permitted activity standard which requires non-compliant consent for extensions or alterations to an existing building or structure which accommodates a non-compliant activity under another provision. Now, I recall that this was some time ago. I'm scratching back, it's been a bit of a long process, but recall that back in the rural hearing of this, I raised this point around having this double up to say if the activity is non-compliant, therefore we're going to make it that it is non-compliant under this building right. In my opinion, I see that as totally unnecessary and redundant. If you have an activity which is a non-compliant activity, you have the scope to consider the building. I do not see it as necessary, helpful, efficient or effective to include another trigger within a building rule to link non-compliant activity status. Therefore, I've recommended that that's deleted, and that's pretty consistent with the position I took in the settlements for food stuffs as well. So here's the recommended amendments. So as I've put in here, I've recommended that the clause that increases the existing building footprint is added there, and it just makes it clear, like if you're not increasing the building more than maximum height, or in relation to boundary, etc., you're still going to have those requirements in the other. So I've actually added a new one, which is per X. So I've said you still have to, if you're not extending the footprint, you're still going to have to consider maximum height, because naturally you might increase the height of the building but not the footprint. And then a height in relation to boundary, of course, again, because you could add an extension to a building. So it's not trying to get around the standards. It's just making it clear that per one, that you're not going to trigger, for instance, a pedestrian frontage requirement when you're doing alteration, which is not extending the footprint of the building, which I would argue is what the intent of those provisions is. The second change I've highlighted there and just discussed is deleting per two, so any extension or alteration to an existing building or structure where the activity is non-compliant. As I mentioned earlier, I just think that is totally unnecessary. If you let the activity rule, it's determined to be non-compliant, stand on its own 2 feet. You don't need to add another clause there. So I might just pause there and I'll carry on. Okay. Town centre zone rule 2. So this is the commercial activity rule for town centre zone. Now, again, if you reflect back to my point around nesting tables, definitions, commercial activity is the broader term, I would argue. So commercial activity will include a retail activity, will include a supermarket as well. So one of the things I immediately picked up was in the rule title, and I'll come to this in the next slide, it refers to trade and yard-based retail. Now, looking back through the definitions and recommendations to date, there is no definition of trade and yard-based retail. However, there is a defined term, as I understand it, for trade supply. So that's an instance where it's really important to be carefully looking back through these to make sure that if you're referring to an activity, it has a defined term that you are linking that, so you don't get the confusion. But then also that flows down into the argument of nesting tables. So even though that's not an interest of foodstuffs, I have, in my duty of care, picked it up to say, well, I think this is an issue that you should fix because that's the defined term. There's a permitted standard there again, which refers to alterations or extensions to existing buildings, and I argue that is already addressed by Rule 1, which refers to buildings. Rule 2 is about the activity, so you'll see a change in there. Again, we've got this feature where the GFA limits have popped up again. Now, again, I haven't actually necessarily recommended a change here because in foodstuffs, what I've sought on behalf of foodstuffs and its submission is that supermarkets are excluded. But I still consider there's this lack of justification as to why these gross floor areas are here. In fact, there are two. There's a 450 square metre one, I think, if you're within a pedestrian frontage overlay, and then there's a 1,000 square metre one if you're not. And I can't find any basis for that from the council documentation, and that goes back to the section 2. So why is there a 450, but then also why is there a 1,000? Where does that come from? What effect is it effectively going to manage?
I thought there was debate around the 450 going to 500 based on some of the work you've done earlier.
That's in the settlement zone.
Yes, that was so that was in the settlement zone. So
supermarkets and settlement zone.
Yeah, settlement zone. So, and again, it all ties into the point I was making in here in 14 about bulk format retail. Yeah.
Yes, so
yeah.
I recall we asked you to provide us, we'll go back to a client, Foursquare.
Yes,
And
yes, post-settlement, yes.
Yeah, what do they consider to be the minimum viable floor space? And I think
Yes.
we came back with 500.
I'd have to double check my numbers, but it would have been between 500 and 600. So that was for a 4 square, which would be much more suited to a settlement zone. However, in a town centre zone, you can already see it evidenced by what the existing activities you've got there now. You have two large, now I don't know the floor areas of the new Kerikeri, I don't know the floor area of Woolworths Kerikeri, but I imagine it would be well over 1,000 square metres, and they are not, what's the word? That's pretty consistent with the size of the supermarket that you would anticipate in the town. And in my opinion, I don't see that as a problem. You want to encourage and facilitate commerce and activity within there, and those supermarkets are existing and will over time want to expand.
You would see that 1,000 square metre threshold to go up?
Well, possibly. Like my recommendation and my evidence is in fact just to exclude supermarkets from this rule, and I'll come to that. But
you're going to make the same case that you made in 4 square, that supermarkets have a special type of retail, because I suppose the general concern is that other non-retail, non-residential activities like LFR, like large format retail, might swamp some of the traditional retail in the town centre that the previous submitters spent quite a bit of time urging us to protect.
Yes, and so the approach I have taken here is to specifically exclude supermarkets from this rule rather than sort of getting into the. And the reason I've done that is because it's actually consistent with the council recommendation and the right of reply for the mixed use zone. Well, actually, yeah. So the 42A report in the mixed use zone was to have its own rule for supermarkets. So I've essentially.
Follow the
yeah, I've followed the Mars, but I haven't really gotten into the weeds about. I wanted to. There doesn't seem to be any clear justification. Now, you could argue about the 450, but then the 1,000 square metres and the lack of any actual assessment, section 32AA, I don't know where that number has come from. But the approach I've taken here with this rule as it relates to foodstuffs is to say, well, actually, probably the most efficient and effective way to address this is to exclude supermarkets and have its own rule, which is similar to what was done in the mixed use zone. And look, I highlighted here, so why is it there but not for, say, a healthcare activity or a community facility? Now, a healthcare activity, you could argue, yes, they might not need a GFA restriction, but then a community facility, go back to the definitions, the nesting tables. There's a lack of really clear justification provided by council. I think if there's anything to take away from that point, that's what I'm saying. One of the other points I observed is the matters of discretion in the rule read like assessment criteria, in my opinion, rather than clear matters of discretion. So I have recommended redrafting them to be a lot simpler and clearer, and I consider give the adequate scope of what you would assess under that rule. So in my recommendation there, I've already sort of highlighted it. I will go on to the next slide and just show you the wording. So this is the rule. The key changes I have recommended are in the title, so commercial activity, and I've recommended putting in trade suppliers because that's the defined term. And I've also recommended excluding supermarkets. In terms of the rule itself, the original sentence, a little bit hard to read there with the highlighting, but the original leader sentence said, any new non-residential activities or extensions or alterations to a building or structure is. Now, I think this is quite an important point. The rule title is commercial activities, but then per one, and the first sentence refers you to any new non-residential activities. So I would interpret that as what's the definition of residential activity? If it's not that, it's a non-residential activity. I can't understand why you would put that term in here when it's related to the commercial activity itself. So I have recommended deleting that. I also recommend the extensions or alterations to an existing building. It's not the purpose of this rule. This rule is about the activity. So my recommendation is that the rule will read the new activity or extension to the existing activity is. I haven't touched the limits on here because, again, in foodstuffs scope of its submission, if there's an exclusion for supermarkets, then it's not really to go there. But I would recommend looking at those.
So you wouldn't use the word any new commercial activity?
Well, yeah. I think you could use the term the new commercial activity. Yes. Yeah, and I think that would make it very clear that it's linked to that. But the reason I used the new activity was because I was primary to the activity, but the leader sentence is commercial activity. So if you see the new commercial activity or extension to an existing activity, that's. And finally, thirdly, I have recommended new matters of discretion. I haven't included the ones that I recommended, that's in my evidence, but you can see the ones that I have. And again, I've linked this back to I've tried to link this back to the objectives and policies and what's being achieved, because that's, the objectives and policies set our framework, which the provisions are trying to achieve and get effect to. I have simplified these, so I've included 5 matters there: effects on streetscape character and amenity, building bulk and design, privacy and amenity effects on adjoining sites outside the town centre zone, because that's primarily, I would say, we're concerned, and then also crime prevention through environmental design and the functional operational requirements of the activity. In my mind, if you were to go through this and trigger a consent, that's the matters that is to be restricted to discretion. Those would be the matters that I think are relevant.
What about the one where we talk about provides a human scale? That would seem to be quite important. It seems at a glance that's one that you haven't picked up in your summation.
Yeah, so I would say building bulk and design give you a very wide discretion to look at that. It's not specific, because I would read those matters as assessment criteria rather than matters of discretion. If you look at effects on streetscape character and amenity and building bulk and design, you've got wide discretion to consider relevant matters.
I have a supplementary question to that. We heard earlier today about Kerikeri specifically, but in general wanting to have the village feel to the town, and arguably having a big box development, human scale, and having the urban design principles being applied to it may have a better outcome for the community. What's your response to that?
I did briefly observe online the presentation this morning, but I can't say that I observed it in full. What I would say is that, from a planning perspective, in my opinion, based on my experience, I would support matters of discretion such as this. They give scope for those matters to be brought in. Now, I know that there was some discussion around urban design guidelines. It's not something I've touched on. I do, as a wider sense, I do question their value. Especially if you want statutory guidelines, and the real key from a planning perspective is how you would integrate that into the provisions. But if you're looking specifically at these matters of discretion, I think you've got, they would give broad scope to consider those matters.
But I think a planner would say that, because planners like to have unlimited scope.
Yeah, well,
we're trying to make them more specific, and I'd suggest to you that the point that's just been made about the village atmosphere, and that's what we're hearing from the submission this morning. Was that was particularly important in Kerikeri, and we've got to maintain that building bulk and design. Sounds like it's been driven by an engineer.
Yeah, look, I've taken this type of wording from other plans in other countries. So generally, in my opinion, for a matter of discretion, try to keep the wording quite simple. The previous wording, in my mind, read more like an assessment criteria at the extent to which.
Also today we heard about heights.
Yes.
So, and also that the community said they didn't feel that they wanted a town centre zone. They said, why not mixed use for the town centre? And also they said, no, 6 metres they only wanted, 6 stories they only wanted, 3 stories, 12 metres. What's your response to that?
So I've got no specific submission point for foodstuffs on that, but what I would say from my own opinion is 6 stories as a vibe seems pretty high. Pretty high for Kerikeri. It's quite different to what it is now. It's about a 2-story limit. Probably the John Butler Centre might be maybe the tallest building in there. So that does seem like quite a steep change. Height limits aren't really primarily a concern for foodstuffs, but from my own perspective, I could see why that would roughly future this.
So your standard foodstuff supermarket would be 12 metres?
Yeah, it wouldn't be fringe.
If that, actually.
Yeah, if that. So, again, so that, I think I would argue that for a human scale, if that's what the primary matter which is trying to be addressed, then the height limit will probably be the rule that you would look at. But again, I'm not an individual. I'll be purely commenting on that based on experience. And then finally, so as I've recommended as a rule, and supermarkets permitted. So this This is consistent with the MUS. There was a rule that was created, and the commercial activities rule in the mixed use zone was also exclude supermarkets. So what I have done there is consistent with that, but in the rule I have, as I've already indicated, I've picked up some other things which I think should be fixed as well. So this is large format retail. So I'm just going to, again, I think we've traversed this quite a bit in hearing 14. So you have, again, with the nesting tables and the definitions, you have this non-compliant activity status for large format retail, which contradicts TCZ Rule 2. Because you have commercial activity and you have, okay, so the point I make here is if you look at those gross floor area limits, a non-compliant activity status for, as it currently stands, for large format retail. Large format retail includes a 450 square metre limit in definition. But then you have a rule, TCZ Rule 2, which says you can be permitted up to 1,000 square metres outside of the...
So your approach is exclude supermarkets?
Exclude supermarkets, but I think highlighting to you that there is a wider issue here beyond foodstuffs submission that I think needs to be considered. And that is that if you're going to say something is non-compliant, but then you have a permitted activity rule which says if you're up to 1,000 square metres outside of the pedestrian frontage zone, you're permitted, you have a conflict between the two. And I don't think it's a helpful one. Now, again, I have addressed this in terms of foodstuff submission by excluding supermarkets. That's the same as what was recommended in the right of reply for the mixed use zone. So it addresses that, but I would be remiss if I do not highlight that I think there is an issue here. Yeah, look, I made the point, I think supermarkets are a key community asset, provide essential goods and services, and typically expected to be located in town centre zones, as is indicated by the presence of the two biggest supermarkets in there now. And look, and I link that back to the objectives and policies in my evidence, but there is no clear foundation or basis, in my opinion, in the objectives and policies to have very restrictive framework on commercial activities, particularly supermarkets in this instance. And that's what I say at the last point. There's no avoid. There's also no avoid to it. You know, typically in my mind, if you're looking to avoid something, you know, if it's a qualified avoid, you probably have a non-compliant activity status. If it's an unqualified avoid, it could lend itself to a prohibited activity status. There's nothing like that in there for large format retail and the objectives and policies in the town centre zone. So the key thing is following all that, looking specifically at this briefing evidence is I recommend that it excludes town centre, excludes supermarkets. What I've put.
So just on that, in Ponsonby and other towns that we heard this morning that have the village feel that Kerikeri wants to have, I know there's a supermarket that's in Ponsonby that's got quite great design features in terms of. Don't you think that with changing, or do you think that with changing and not having the criteria about human scale and having those design functions in or out the pedestrian frontage areas would lead to traditional style supermarket designs instead of what they're asking for, like the Ponsonby type village feel?
Look, I think quite separate things. What I'm talking about is the activity and the rules for the activity. I think there are also building rules, so building bulk and location rules, like height relations, boundary, height limits, all of those things. And I'm not proposing that those be changed. What I'm focusing on is the activity itself. So if you're looking to control urban design features, in my opinion and experience, that is done through bulk and location provisions primarily. So obviously Ponsonby is in Auckland unitary plan is a completely different kettle of fish to dealing with up here. I probably wouldn't say it's comparing apples with apples, but the point I'm making is the activity. It's the activity, not restricting the activity. If you're worried about how the appearance of the building, that is primarily done by bulk and location standards, and you already have in this zone, consistent with the mixed use zone, a pedestrian frontage rule, a glazing requirement as well, which again, we addressed that in the hearing 14 as related to New Parkway, but I accepted the urban design evidence there that it was, it's an acceptable tool to use. So I think those matters are addressed by the standards and building rules, not the activity rules. So moving on to the standards. So again, I'll just summarise these and I'll go to the slide to show you what I've done or recommended. There's a standard Standard 6, I just recommended that excludes the town centre zone in terms of the landscaping requirements, and that's consistent with what has been done in the mixed use zone. So I don't see that as a particularly complicated one. It's probably one that just needs to be added in, so you're not having to address it adjacent to it, much like you do within sites zoned mixed use zone. There's another rule, Standard 10, it refers to council's articulated network. Now, as I understand it, the town centre zone is within council's articulated network, but I question the need for an engineer also to assess compliance with that rule. It's 10% permeable. Why does an engineer need to confirm that? I think anyone can confirm if something is permeable. An architect does that. Council planner can do that. I don't think it necessitates an engineering system. I've also recommended, similar to my previous ones, to simplify the matters of discretion. And then finally, one of the last standards I picked up on is there is a sub-standard one. Now, it might be me just misinterpreting this, but it was included in here and it had no controlled activity, no minimum allotment size as a controlled activity, and no minimum allotment size as a discretionary activity. I don't disagree with that. It was more just its location. If that was intended to be in the subdivision chapter, then that's where I think it sits. But also, if you're going to have a standard which says no minimum discretion or no minimum control, why do you need to have a discretionary threshold? Because there is no pathway to discretionary. So that's a simple thing I identified. So here are these rules here. So this is the first one, Standard 6. I've recommended including town centre and town centre zone in there, and it's consistent with how this is done in the mixed use zone. So you're not triggering the landscaping rule. These landscaping rules, they're primarily designed to protect the external other zones, so like where you abut a residential zone. So for me, this just looked like an omission, so I've recommended including town centre zone, and it's consistent with what's happened in the mixed use zone. The second one is this. So you'll note here that I didn't talk to it, but I have changed the rule reference because you'll see this in the other slide. There's quite a few jumps between rule numbers. It goes from Standard 6 to Standard 10, so I have recommended fixing that. And this is the rule, so at least 10% of the site should be planted in grass, vegetation or landscape with permeable material. And then there was a requirement which I recommended deleting, which was where a connection to council's articulated stormwater system is not available, the stormwater system must be disposed of within the site. Now, let's make a point that this is, as I understand it, it's within this articulated stormwater network. But also the next point of an engineering report, site suitability report is required for compliance with these standards. Even if you decided that you wanted to keep Standard 2 in there, Clause 2 in there, I still don't see why you would need an engineering assessment. If it's either not, it's connected to the stormwater network, or it is. You don't need a site suitability report to conclude that, in my opinion. Now, I acknowledge that this is in the mixed use zone. I didn't pick this up at the time, but it's a similar point I'm making. But I think for the town centre zone, Kerikeri, as I understand it, it's in the articulated network. So. And then again, I have recommended the matters of discretion below. So I think stormwater management, you've got a permeable limit. You're going to want to look at stormwater management if this is infringed. It's also landscaping, so streetscape character and amenity will also be important. And also obviously the planting. If you're proposing less planting, is this appropriate to meet? So.
I wonder how you've structured these points to generalise them from being informed of whether the activity is within, etc., etc. Does that seem to be the way people were applying those matters of discretion in terms of other district plans? Is your experience, given you've got experience in other district plans as well, is that how councils are dealing with those matters these days? Do the matters of discretion simply the title of what might be considered rather than being more specific?
There's variable practice across the country. I consider this type of approach is better. Sometimes less is more. I think when you write quite a lengthy matter of discretion, and I think that the nature of the previous law I referred to really does, in my mind, read as assessment criteria rather than a matter of discretion. The matter of discretion gives, in my opinion and experience, gives you this is what you can consider, and you think within this, and then your assessment of whether that's acceptable or not could be done by recourse back to the objectives and policies in the 104 assessment or assessment criteria. Now, we don't have assessment criteria in this plan, and I'm not suggesting to, but this is how I would recommend that you structure for these rules in particular. It's just clear. I think it's clear.
Okay, thanks.
And the final one was just this. So this was what I was talking about. Again, it might have been like, I assume this will be in the subdivision chapter and it's probably included here. But to me, it didn't make a lot of sense having a controlled activity. Says no minimum lot size. How do you get to a discretionary activity if there's no control? There is none. There is no minimum lot size. That's the point I was making there. Obviously, there's going to be other, and I absolutely support no minimum lot size in the town centre zone. You don't be arguing around a lot size in the town centre zone. So support the no lot size. I just think how that is presented is unhelpful and probably unnecessary. Could be simplified. Moving on just to some other changes. So, and this is just what I highlighted earlier. So there are inconsistencies and errors throughout the town centre zone provisions that require amendment. So numbering errors, rule duplication, and inconsistent referencing of change, which I think I've touched on already. What I think they show, they're quite easily identifiable. And I think what they indicate is there's been a real lack of careful scrutiny of the provisions themselves. And I don't mean that as a slight. I mean that as like it needs someone to actually really carefully look through these. So I've just picked up things in the last 2 weeks I had to write this evidence, albeit probably a day, and I pick these things up quite easily. So I think there is a need to actually quite carefully go through the town centre zone because I think there will be more. These are just indicative of the issue. And finally, there was the consequential changes. Now, they were listed as a table. I just think it would be really helpful if they were consequential changes and we could see how they operate. Now, at the moment, listed as a table, having to then go to the rule, figure out how it's adjusted. I know there's a suggestion that the medium density residential zone will be the general residential zone and the town centre zone is going to be the mixed use zone, consistent with those. But until you see that on face value as consequential changes, there's a lot of uncertainty there for submitters, and I would argue the planning, precisely what council are recommending. So I think that should be shown so it's clear for everybody. So this is just an example of what I was talking about. I've highlighted these up here. I do raise these in my evidence towards the end. You have these rules. So the first one I'd highlight would be this one. So you have emergency services facility is permitted, and then it says activity status with compliance not achieved in PER 1 discretion. There is no PER 1. It's a permitted activity rule. So that just looks like a clear area that needs to be fixed. The other one I would highlight is there are 2 healthcare activity rules. Now they say the same thing, but there's rule 6 and then there's rule 11, and they both say permitted. So I think that's something that needs to be fixed. And then, as I also alluded to, you have this issue with the rule numbering where you go from rule 7 to rule 10. Now there's other things I've picked up and identified, but I just wanted to show you this to be like this is indicative of what I was saying. It really needs a careful work through these to iron out these issues before this is going to be incorporated as your decision into the plan. So sort of drawing to a conclusion. So, as I said at the outset, I generally support the application of the town centre zone spatially. I don't see that as a problem. I think the lack of a targeted assessment and justification makes understanding the rationale for the rules problematic, and it does undermine integrity because we don't actually know why certain things have been recommended. I have identified I'm particularly concerned with the GFA limits, but how I've addressed that as it relates to foodstuffs submission is to exclude supermarkets by that as we get through. I also consider supermarkets should be excluded from TCZ Rule 15, and there should be a number of targeted amendments to the town centre rules, zoning rules as I've outlined, to improve the clarity, remove duplication and redundancies. So I think that's carefully look through. That's the conclusion of my presentation of foodstuffs. I'm happy to take any questions. I do have, as I mentioned earlier, I have a couple of slides for McDonald's that I'd like to take you through. They are largely the same because the issues are very much aligned. But I'm happy to take some questions on this first before I jump across to that.
Well, we sort of asked questions along the way. I think it'd probably be more effective if we hear your McDonald's evidence and then we'll sweep up any further questions.
I'm happy to take questions on both. If it comes to it.
I mean, we've been throwing them at you as you go, so I assume you're happy with that.
Yeah, I'm happy with that. So I will just bear with me if I transfer across. This won't take too long because again, they're very similar issues. So I'm actually, I'll pre-circulate, I'll circulate after the presentation, so you've got them in send it whole, but I'm actually just going to skip to the bits that are different because they're largely the same. So the first one to highlight is that's where the McDonald's is in Kerikeri, as you know, it's basically right in the centre of the town centre zone. There's the existing picture of it.
It's a little different.
Yeah. And what I would highlight here, the main point of difference relates to this rule here, drive-through activity. So you have a non-compliant activity status for drive-through facilities in Rule 18 that sort of pops up. The first thing, actually, I didn't address this first point. I didn't actually address in my evidence. I only picked it up when I was preparing this presentation yesterday. The rule refers to drive-through activity, but then the proposed defined term is drive-through facility. So again, there's just that careful consideration of terms used in the plan to make sure they're consistent and aligned with defined terms. So that's one I just picked up separate to that. And here in 14, Council have recommended that a definition of the drive-through facility is included. So I've just recommended that if you are, it's called the rule. Well, I recommend deleting this rule, but if you're going to have any reference, it should be consistent. Drive-through facilities, and we'll discuss this in here in 14, they are a commercial activity. And if you have nested definitions, they're quite clear: commercial activity, retail, drive-through facility, and for everyone there. So there's a non-compliant activity status, and there's no clear directive within the objectives and policies that I can see that has resulted in this rule. So you have this instance where a rule has shown up, and I'm looking at the objectives and policies. Now, a non-compliant activity status, in my mind, is something that's not anticipated or provided for, but also should have some basis as to why. And I can't see anything in the objectives or policies that leads to saying why the activity should be non-compliant in town centre zone. I made this point for in hearing 14 around other provisions in the plan. So if you recall, for hearing 14, there was a recommendation in the mixed-use zone that a drive-through facility should be restricted to special activity. And I link in my evidence, I do link back to that and say, look, I've already made this point, which was that they're actually already, the matters of discretion around there are already addressed within other provisions of the plan. So traffic, access, bulk, location, signage, noise, lighting. We have standards for bulk and location of buildings. We have standards in the town centre zone. For signage, we have a signs chapter which quite clearly outlines signage requirements. For noise, we have a noise chapter which has clear daytime and nighttime limits. And again, traffic, we have the traffic requirements in the transport chapter. So I'm making the consistent point that I don't see any need to have a specific rule for drive-through facilities in this zone. It will result in double handling, and for this, in the scope of McDonald's submission, I think it should just be considered as a commercial activity, which is in TCZ Rule 2. I've already talked you through my changes of those. They're consistent between the two precedents. So I haven't sought to exclude drive-through facilities from compliance with that rule. If it stands, it's fine. But I don't see any basis within the provisions themselves to lead to a non-compliant activity status in drive-through facilities. And so that's why I've led to the recommendation to keep it to exclude that. And look, the rest of these are all very consistent, so I'm not going to go through them again. They're basically the same. So I will circulate that.
I think it's pretty clear. I'd be interested in the officer's responses, but yeah, nothing to ask.
The only question I had about drive-throughs was if it's addressed at all, which I don't think it is, within the transportation section of the plan, and if you feel that that could be an option as well, given it's essentially a traffic effect.
Yes, so I'm going with recollection here, but there is the ITA requirements that are in the transport chapter, which list the GFA limit for a drive-through facility. I'm going to tell you off the top of my head what they are. It's possibly a question for council officers, but it's quite large. And so there is already a trigger there for the ITA requirement, which is where you assess, in my opinion, what the transport effects of So if there's no imperative to control activity, I think you let the district-wide provisions and bulk standard provisions can address those effects.
I don't think we have any further questions for you. So thanks again for a detailed and concise presentation.
Hopefully I saved you a little bit of time, maybe not as much as I hope.
We appreciate the effort. Audrey Campbell-Fred. You'd all like to come up and the legal counsel on your way there.
So did you want to? Okay, cool.
Well, good afternoon. Thank you for your patience. We've been trying to proceed through our earlier submissions with alacrity, but I don't think we're too far behind time. Can you give us an indication of how much time you'd like to present?
Thank you very much, Chair. We requested an hour for our presentation and we're working very hard to stay within that. Meeting to my colleague who has clawed back some time, very generously.
No, well, I think we've got at least that. So that's good. Don't feel like you're under any pressure. Fortunately, we've got evidence that we've read, but we've got plenty of time to hear summaries and. So Ms. Campbell-Fred, you've got a statement which you can read out to us if you wish.
So the order we thought that we would do today, which has been a bit of a moving beast, we've gone back to the more traditional format, so I'll do the legal submissions first, and then because Audrey wanted to make a statement to you, she will do hers, and then we will go to the PowerPoint, which is Ms McGrath's planning summary, but also quite a good introduction to the technical evidence.
Yes.
Mr Hills has the last two slides of that, which is the traffic aspect, so he'll go next. So we should have Mr Hills and Mr Boyd online. So we'll do.
They're not related to.
Yes. So we'll have the planning PowerPoint, then the traffic, and then the economics. And I think in previous hearings we've actually ended up with a bit of a sort of a Q&A session at the end with myself and Ms McGrath. We're happy to do that or to take questions as we go along. But that's the proposed format that we've got. Do the legals. And because we're in this sort of minute 14 environment, we often allow council officers to comment as well. Yes.
And that might clarify some matters. We'll see how it goes.
I have also introduced myself this morning to council for the district council. I understand the primary reason for Mr Fisher's involvement was largely around okay photo, rather than the more disparate submitters, but we have made contact this morning and
He's here nonetheless.
so I hope that the panel have a package of papers. So we'll start with my...
So, I've got your legal, so I've got everyone's evidence and legal submissions on my laptop.
Yes,
so
thank you.
If you see me tapping away, that's because I'm making notes on my laptop.
It's not the grocery order. So just the first page of the legal submissions, starting with the introduction, you'll be delighted to know, I'm just going to skip that. It's the housekeeping aspects of the submitter number, what the themes of the submission were, and what we're here to talk about today. Paragraph 1.6, I will note though that Ms Campbell-Freer is grateful for the panel's directions that allow the submitters in 15C and 15D to nominate one hearing to appear. That has made a massive difference to our case presentation because we were genuinely cleaved across the two hearings. So we would have had to have come twice otherwise. Moving to paragraph 1.7 at the top of page 3, the spatial extent of the horticulture precinct. And I don't know if you've spent much time on the spatial extent of the horticulture precinct. I think it may have been picked up last week as part of 15C.
Yeah, we did spend some time
yes.
Looking at what was in and what's been suggested to be taken out.
Yes, thank you. So Mr. Foy, Ms McGrath and soils expert Mr Hanmore presented evidence at hearing 9, which feels like decades ago, with respect to that proposed at that time horticulture zone. The council accepted that the zone did not satisfy the criteria for a special purpose zone, and the panel issued interim guidance that it is likely to recommend that the zone be redrafted as a precinct, with the spatial extent to be considered at hearing 15C. To recap, in very, very summary form, Mr Foy and Ms McGrath's evidence from hearing 9 stated that the rural production zone plus the NPS HPL provides for horticulture and manages reverse sensitivity. The horticulture precinct provisions duplicate, are inefficient and are unreasonably restrictive. More horticulture and irrigation is found outside Kerikeri-Waipapa than in. Horticulture is not a majority land use in the horticulture precinct. Irrigation is constrained in the horticulture precinct, and the majority of land in the horticulture precinct is too small for viable horticulture. The hearing 9 reporting planners recommended precinct wording has added an entirely new independent spatial mapping criteria for horticulture precincts to policy 1, and that is that the land provides an effective buffer to manage reverse sensitivity effects on horticultural activities. So the reporting planner's supplementary evidence stated that this significant addition clarifies and better reflects the intent of the zone, now precinct. Dr Hill's report on, I think I'm correct, I don't know if Reese Hill is Dr. That's right. Dr Hill's report on spatial extent of the horticulture precinct states that the intent of including 33% non-horticultural land in the zone was as buffers to manage interface and reverse sensitivity. So now the precinct and Dr Hill's evidence are both talking about buffers, but the section 32 report for the zone did not refer to buffers. It's not in there. The reporting planner's supplementary evidence also states that the new buffer spatial mapping criteria will be explored extensively as part of the rezoning hearings. As far as we're aware, that hasn't occurred. We have not seen any 42A detailed exploration of this new concept of buffers. The council has not spatially identified which land in the horticulture precinct is horticultural land to be protected on the one hand, and which is included as buffer to protect that land on the other. There is no section 32 assessment of different options for the extent of a buffer, which should include no buffer as one of the section 32 options, whether the rural production zone adjacent to the horticulture precinct acts as a buffer, or whether provisions could be added to the rural production zone to buffer adjacent to the horticulture precinct. There is no section 32 assessment of the costs of the buffer, which are borne by the properties within it. The proposed precinct imposes significant planning burdens on land solely to protect a private industry without section 32 assessment. I'll just intersperse there, the reporting plan has now made it quite clear that the precinct is completely divorced from and unrelated to highly productive land. It's not implementing the NPS HPL, it doesn't refer to highly productive land. So it's not for that, it's for protecting the industry. Ms McGrath maintains her opinion that the precinct and its spatial extent are not appropriate. But if you decide that there is to be one, your opinion is that it should not apply in locations 1, 2, or 3, and we are going to take you to those. We'll just bring up the area map so you will be refreshed on what our 1, 2s, and 3s are. Hopefully you can see that, and those online can see it. So area 1 is the red, so that's the proposed rural residential. Area 2, the light blue, which is the Kerikeri Road, the pack house node, and area 3 is the redwoods that you heard about.
Mr. Otway's.
Mr. Otway's, yep. A plan would have been hanged this morning, but Mr. Otway's redwoods is on State Highway 10.
Thanks, that's very helpful.
So in my legal submissions, just moving to the first of these zoning themes, so bringing ourselves into, again, hearing 15C when it comes to rural residential. The 15C reporting plan opposes zoning of location 1 to rural res, primarily because zoning additional rural res on the urban edge signals an intention for urban growth inconsistent with the spatial plan and will increase reverse sensitivity and lacks traffic assessment. This response has to be seen in light of, now you have a single sheet handed up to you, which is a coloured plan. Yes. If you have that in front of you, the very attractive black hatching was my hand-drawn addition, because if your eyes are anywhere near as bad as mine, the difference between the grey spots on pale green and the grey diamonds on pale green was very difficult to see. So if I can just take you very briefly to that plan, the area in red that you can see is location 1. That's what the submission evidence now seeks to rezone to rural residential. Just go back to the 3 areas. And the hatched black is the area that is operative rural production, but the council notified as additional rural res. So on the key, you can see that the operative zoning of that pale blue, pale purple colour was rural living. That's now proposed as the rural residential zone. And the area that I've hatched in the black hatching to make it easier to see, on notification of the proposed plan, the council included additional rural production land into its rural residential zone, and the area it included is that area I've shaded with the black hatching. So hopefully that is clear that the zoning underneath is the operative zoning. So the hatched area is the piece that the council notified as new rural residential. So before we move on, because that's critical to this part of the legal submission, so the evidence, is that clear as mud?
Yeah, so essentially your land adjoins that new rural residential boundary, and you go all the way down to the river, correct?
Well, Ms Campbell-Frere's land is part of that red area, and yes, her land does adjoin the stream on the southwestern sort of edge of the red. But what we wanted to make spatially clear to you is that the area that we're proposing as rural residential
is closer to the road.
Yeah, that's right. So the area.
What's that little lane that the first little lump? Just trying to work on. I've got the planning maps open on my phone.
Up the top or down? The one up the top, Stony Brook.
One's down the side.
Everything's off Access Road. Oh, is it Double A? It's Double A.
Dove is the first one.
Yes.
Yeah.
So I think it's literally between that long right of way, including Double A, adjoining that Double A area.
Yes.
Okay.
Yeah. And so critically from our preparation of the submission perspective, the proposed district plan had notified additional rural residential land to the north of this block of properties. It had used the stream as the defensible boundary for that extension of rural residential, but it had created this dogleg. So if I can take you now back to the submissions, if we're all clear on the pretty picture. First bullet point in 113, the reporting officer's response to this submission has to be seen in light of the proposed district plans. First, creation of the special purpose rural residential zone. The council notified the zone as a special purpose zone. It invented this zone for areas that had previously zoned rural living in the operative plan. And the council described the zone as, or the zone describes itself as, in a location where an urban area may grow and where land may be rezoned for urban development when demand requires it. So the council, on notification, chose to include the rural residential zone, chose to include it in this location on the edge of the Kerikeri urban area, and chose to extend it from operative zoning across some rural production land. The second bullet point, zoning of additional land from rural production to rural residential zone in several locations, not just this, prior to notification, and including this area that I've shown you immediately adjacent to location 1, where the stream was used as the new defensible boundary, creating a dogleg. So at paragraph 114, location 1 is an existing rural residential developed area immediately adjacent to notified rural residential zone and contiguous with the urban area. It's not greenfields, it's not a farm, it's a rural residential scale, lifestyle blocks, houses, there's houses there already. The NPSUD supports housing choice. Mr. Foy, with assessment by Mr. Hanmore to assist him, has confirmed that the NPS HPL zoning test is met and that there is demand. Mr. Hills, Mr. Hills, we've got a Dr. Hill and a Mr. Hills, it gets very confusing. Mr. Hills, Transportation, has confirmed that there are no traffic concerns. Ms. McGrath has identified a maximum of 26 additional allotments. Now that's a conservative estimate, that doesn't allow for any losses for access or services, maximum of 26, but you wouldn't get 26. She's addressed reverse sensitivity and she supports continuing the stream boundary already used by the council for the rezoning as a defensible boundary. So that is location 1, rural residential. So my submissions then move to the mixed use zoning for locations 2 and 3. So just bring that back up. And as you can see, I'm on the last page. The hearing 15.
Before you go through there, can you just tell us what's in that area 1 at the present time? What's the nature of the existing activities? I know you've spoken about it generically, but
oh, I'll let Ms. McGrath cover that. She's got a PowerPoint with some aerial photography and some photographs. So yeah. So it's lifestyle, rural residential and lifestyle. Yeah.
Oh, thanks.
I mean, we want to visit the property. We're actually, I mean, it's literally just up here, right?
It's just right.
We're going to be doing a number of sites. Are there any issues? I mean, can we get it just a bit on public roads or domestic council?
This is all multiple ownership, so we couldn't tell you whether or not we could access that.
You can you can view all of the frontages from public road, and Ms. Campbell Freer's property has got the Kerry Berries at the beginning, which has got a large gravel pulling area. You can view quite a lot from there.
Actually, as it turns out, the KFO people are going to take us up in a helicopter tomorrow, so I might just say, do a little dog leg.
So to orient you just in this part of the submissions where we're talking about mixed use zoning, for location 2, if you have in your mind,
a couple of houses.
If you have in mind basically where we are sitting now, Makana, the Pack House, Kerry-Berries,
yes. We can see all of those from the road.
Yes. So that's location 2.
It's wanting to get into the guts of
That's
of the red area.
Yeah, it's a variety of different owners in there.
How far does access road take us into the property? Would that be sufficient, you think? Yeah, well, let's just, okay, maybe we'll just see what Ms. McGrath demonstrates to us, and that might.
We can also have a chat to Ms. Campbell Freer after the hearing and see if there's any, because these are all good neighbours as well, so it may be that she could make some arrangements for you.
We are endeavouring to get around all these, in particular the minute 14 sites.
Yes. I'm just conscious of time, so I'll move moving.
That's okay.
So the mixed use zoning locations 2 and 3 is here in 15D. The reporting planner opposes locations 2 and 3 being zoned mixed use for the precinct. Primarily that opposition is for economic and spatial plan reasons and because existing activities can rely on consents and existing use rights, which is something you discussed with Mr. Otway this morning. There are existing locations, these are existing locations of commercial development. Again, not greenfields, it's all there. Mr. Foy, with assessment by Mr. Hanmore, has confirmed that the NPS HPL zoning test is met. There is demand, and that rationalising the existing business nodes with MUD zoning is appropriate and necessary. Mr. Hills has confirmed that a minor addition to the precinct provisions would address any cumulative traffic concerns for location 2. And I note that the council is apparently satisfied with its district-wide traffic rule everywhere else. So its own proposed rezoning would be reliant on resource consents in the district-wide rule. Ms. McGrath has addressed the planning burden of not providing an appropriate zoning, and she's looked at servicing, which was raised by the reporting officer, and she supports the MUDs and the precinct. So in conclusion, from the legal submissions perspective, Ms. Campbell-Fair maintains her submission. I would note that the rezoning that's now proposed on this slide is actually substantially reduced. The submission was very broad, but the evidence process has, I think, appropriately really targeted that down on a spatial analysis of where is it appropriate to actually put the zoning. So the expert evidence supports not creating the horticulture precinct, or at a minimum not extending it to these locations. Zoning location 1 to rural res, and zoning locations 2 and 3 to MUS for the precinct. So I'll just get Ms. Campbell-Fair to do her statement to you.
Well, I just
Maybe
have
one question.
Just one residual question about location 1, and you said that it has a stream boundary on the west. Does the cadastral line up with the stream?
Yeah, it's a great rural stream. No, it's yeah, that water course. Yes, so the water course, we followed the boundary, the stream boundary with that red line of the south-west extent of it follows the water course.
And cadastral boundaries are.
That is the cadastral boundary. Yeah,
okay, that's good. That's the answer to my question. Thank you.
Yep. Thank you. I'll set Ms. Campbell-Fair to you. Thank you.
Tēnā koutou. Ka noho taku whānau ki tēnei rohi mai. I tō rātou tainga mai Hawaii ki. No te kahi me te ururua aho. Ho kona e mātou. Whenua ki ngā mihinari kaniki ki I tahi atu wai. Ko ahau anu te rangatira o te whenua I Kerikeri. Good afternoon. My family's lived in this region since arrival in New Zealand from Hawaii. I'm from the lines of Chief Te Pahi and Chief Te Ururua. My family sold our land in Kerikeri to missionaries in 1926 and moved to other areas that were less attractive to the new settlers. Today, again, my family has legal ownership of a block of land in Kerikeri. Along with my neighbours, who have provided 10 submissions and extensive further submissions among them, I've been engaged in the PPP process since 2022. I'm not a wealthy corporate developer and have struggled most of the time to pay the required experts over the 3 hearings, but have been disturbed by the lack of interest that council planners have shown in producing a plan that has a sound economic basis and one that the community truly supports both now and for future years. For a region that has a population of 37.4% Maori, it is surprising that planners have recommended a town centre in Kerikeri that is Kingsland dense, and without regard to how 37.4% of the population have lived for centuries and may still prefer to live. Clusters of detached housing that still allow for us to garden, but keep us close enough together to share resources, such as a common storehouse and meeting place that we can walk to, is already understood by planners. But we seem to have been consumed with recreating a copy of Kingsland or Newmarket with little thought for the huge difference in our size and culture. I get that planners have consulted with groups through the spatial planning exercise for Kerikeri and Waipapa, but when I know that groups have been provided with targeted questions, not provided with all of the information, or that our councillors have been lobbied by council staff before they voted on the adoption of the spatial plan, I know that our people and the community haven't been provided with genuine opportunity to input into planning for Kerikeri or the district. I applaud the initiative to protect our highly productive soil, to ensure we can grow food for now and the future generations. However, I believe that council planners have been locked into a small window focused on dates and process, and that sensible planning has flown out of said window. The council relied on the availability of Kerikeri irrigation as one of the criteria to determine the new horticultural zone. While being in the area of supply for Kerikeri, irrigation is one thing, having enough water supplied to service horticultural activity is another. Only titles over 2 hectares are eligible for irrigation, and there is insufficient water available to irrigate all of the eligible land. The 2 horticultural uses in location 1 are mine and the Knights, who are shown here, who have plum trees on a small part of their site. Neither of the sites are commercially viable, with owners in full-time employment. These sites have not been commercially viable for more than 50 years, with previous owners trying kiwi fruit, avocados, blueberries, nashies, pineapples and bananas. Due to crop rotation requirements, the sites with productive soil are not large enough for intensive vegetable growing. My site is too small and too close to neighbours to be able to spray crops, and fruit sales are not able to cover the growing costs. Council planners have failed to give attention to the obvious productive soil surrounding our district's new dams and aquifers. They have been unable to answer why, if the rural production zone plus the national policy statement for highly productive land is appropriate to manage all other current or future horticulture in the district, in the Kerikeri-Waipapa area, a highly restricted precinct over fragmented land that cannot access irrigation is necessary or appropriate. The proposal to establish a horticultural zone precinct over areas that are now so fragmented that viable horticulture is unachievable will result in sterilised existing rural residential and commercial land. The existing rural, residential and commercial uses on Kerikeri Road and at the Redwoods should be appropriately zoned to reflect the land uses that have developed and not be subjected to unnecessary cost and regulation simply to serve as a buffer for horticulture on other land. Kei te tumanako, aho te tika te mahi no te katoa.
Thank you. Would you be available for some questions? Can we ask you some questions on your statement? No. Thank you for that. It makes clear sense, and thank you for telling us about your whakapapa and your associated land. That's really helpful. On page, you haven't got paragraph number, so I'll just try and direct you. On your second page, paragraph 1, 2, 3, your last sentence, you said only titles over 2 hectares are eligible for irrigation and there is insufficient water available to irrigate all the eligible land. I'm just wondering, where did you get that information from? And it couldn't be available, made available to us?
It's on the website. Yeah. It's in the hearing 9 evidence from Ms. McGrath and Mr. Foy, but Ms. Campbell-Freer
is so much evidence.
Ms. Campbell-Freer is connected to the Kerikeri irrigation scheme.
But they have a limit. Is it a condition of the irrigation scheme?
So the smaller you are, the smaller the amount is that you're allowed.
Right.
So in my case, there is enough to water the little front piece of the Kerikeris but not the rest.
And that's in your evidence.
It is, and I sourced it from their website. It's publicly readily
When
available.
you say their website,
The irrigation company's
irrigation
website.
company.
And that's the hearing 9 evidence.
That's why I had forgotten it.
Yeah. And we get pinged with a fine if we go over it, we can, and it's expensive.
So I just need to go back to your hearing 9 evidence and you will find that information in there.
Both Mr. Foy and Ms. McGrath discussed that issue. If you do a keyword search for the irrigation, it'll pop up.
Thank you. I need to write this down otherwise. Right. Thank you again.
You're welcome.
Thank you. So next we were going to go to Ms. McGrath's PowerPoint, and again this constitutes her planning summary. And at the end, Mr. Hills has a couple of slides for him to come next. So we'll just play it by ear as to whether you've got questions now or want to hold them until after. Normally the planner goes last, but because Ms. McGrath's got the pretty pictures, I asked her to go first.
Perfectly understand.
Good afternoon, Commissioner. You've got two sets of evidence before you. The original planning evidence that was written before 42A that covered on minute 14 instructions that included a detailed analysis of the criteria that Council had set, and 32AA. So I do not propose to go through all of that evidence. Instead, I've done a summary of the key points and rebuttal pieces. Sorry, thank you for reminding me. It's all blurring together. I won't repeat. You're well aware of the locations that have been focused in as part of the assessment and detailed technical analysis of the areas sought to be rezoned. So I'll just quickly touch upon the horticulture zone / precinct proposed. And again, Ms. Shaw has summarised these points. My hearing 9 evidence raised numerous concerns about the criteria that was used to establish the then proposed horticulture zone, and they were largely based on spatial distribution. So that zone was attached to the Kerikeri area, and in that evidence I raised a number of concerns or issues with the criteria that was used, and therefore the spatial distribution of the zone. So I don't propose to repeat those. I think they've been covered well enough in the discussion already. As Ms. Shaw alluded to, the section 42A has considered this is hearing 15C, has considered the spatial extent of the horticulture zone precinct, and it has used different criteria from the notified section 32. Now, as I read that 32, the whole purpose of this zone was strongly attached to spatial criteria, and now it's a shifting beast, and I cannot see a detailed 32AA analysis of the shift. And as Ms. Shaw alluded to, it is added an additional criteria, which was to establish buffers. And again, I haven't been able to understand the extent of those buffers, the need of them, the spatial location of them. The section 42A has not considered the location-specific evidence that has been provided by the technical experts in support of Ms. Campbell-Freeler's submission. And in my opinion, when I look at the new policy that has been recommended by the 42A officer, so the 42A officer has recommended changes to policy 1, which is essentially the zoning policy. The zoning policy has shifted quite considerably to remove the presence of highly productive land or LUC4 land and replace it with soil and climate characteristics that make it suitable for horticultural use. And when I look at the locations, the 3 locations that this evidence is targeted to, in my opinion, based on the evidence, the technical evidence from the experts on behalf of Ms. Campbell-Frere, these locations are not suitable. I'll allude further to the soil characteristics of these locations in this evidence. The access to water source, such as an irrigation scheme or dam, has not changed from what was notified, so the reporting planner hasn't recommended any changes to that. And as you've just heard, access is limited at best. And finally, the third criteria has not changed, which was infrastructure available to support horticultural use. And in hearing evidence to hearing 9, I rebutted that and identified the issues relating to access to pack houses and the like. So I don't elaborate further there. But with respect to a new clause B that has been recommended by the reporting planner, the land provides an effective buffer to manage reverse sensitivity effects on horticultural activities. And I put to you that locations 1, 2 and 3 are already fragmented. You've heard that there are 2 horticultural activities that may be occurring in there, but certainly not at a commercial scale, and therefore in my opinion, there is no need to create a buffer because there is no reverse sensitivity occurring. And therefore this land is not required to manage reverse sensitivity as this proposed policy puts to you. Turning now to the soil analysis that has been prepared by Mr. Hanmore, and just to assist you, it has been attached as Appendix 1 to the economic evidence of Mr. Foy, and that was purposefully done in order to meet yes, it's criteria, isn't it? The matters in the National Policy Statement for highly productive land and the National Policy Statement for urban development. So the analysis needed to link them together. Now this map, it's a little bit tricky to see up there. So Mr. Hanmore has identified that 9.5 hectares of location 1 is mapped as LUC4. And therefore he has not considered it as
Sorry, I'm struggling to read the key on the screen and the key on your plan. Can you just tell me what the dark and what the key says, please? Oh, that's a little bit better.
Oh, there we go. So the diagonal hatched white to the left is not HPL, that's the LUC4. And then in those main colours, the yellow is a title with minimal loss of HPL. In other words, it's already covered with buildings. And then title with loss of HPL is the brown. But any of those areas that are actually already compromised by unproductive use are cross-hatched in white. So buildings, driveways, accesses and things have been cross-hatched in white because they have no productive potential. So
basically, Mr. Hanmore's done a series of elimination, I guess, to reach a point of concluding that there would be an area at worst of 5.3 hectares of loss of LUC2 land if you were to rezone this area. So it identifies that it is largely fragmented and used for other purposes. And he's taken the same exercise for each location. So the same theory applies, the same mapping key colour scheme for location 2, and that results in 0.87 hectares of productive land that may be available in LUC2, and that's spread over 2 titles.
so those are the 2 brown ones that you can see.
And location 3, which you've already heard about this morning from Mr. Ottaway, again, a series of elimination. You end up with 0.63 hectares of productive land within a class 2 that potentially could have been available for horticultural use. This map you have had in the past, and it just identifies, we presented a series of maps to you in hearing 9 evidence. This highlights the level of fragmentation that is occurring in these areas. The green, the highlighted green and the pale blues are smaller than 2 hectares. So when you look at the locations 1, 2 and 3, or even along Kerikeri Road really, they're all very small in cadastral area.
Can you just highlight those 1, 2, 3s on that? Can you put the arrow? It's a test.
Probably should have matched them for you, shouldn't I?
Yeah.
It's a test.
So 1 is this little pocket here.
So if you can point out where State Highway 10 is.
This is State Highway 10.
Right, there we go.
Yeah.
Okay.
So Kerikeri Road coming in, access road. So yeah, this is your 1, 2 little, it ends actually where these larger blocks are. So there was the logic there. And then this is your redwoods little pocket.
Thank you.
And again, just highlighting the land uses. So you queried what types of activities are happening in these locations, particularly the rural residential location 1 extension. They are rated for largely lifestyle and residential. Like you, I'm unable to gain access to private land, so working off the information that is available to us.
Is the Redwoods commercial?
Redwoods is commercial, yes. And then location 2 has a mix of commercial, lifestyle rating bases.
Yeah, these are out of hearing 9 evidence.
He doesn't.
No, sorry.
You're transfixed.
I like maps, as you know.
That's why we're bringing them.
So turning to the rural residential zone, you've seen this picture. I won't elaborate any further than what Ms. Shaw has identified, other than to highlight that this isn't the proposal to zone this location rural residential is a continuation of what the council notified and proposed. Pretty colour. So effectively, the line follows the stream here. So you've got diamonds on one side and dots on the other. Again, the pale green is rural production zone in the operative plan. The purple is rural living in the operative plan. And the red highlighted area is proposed by council, notified as horticultural precinct, and that is the location 1.
Can you do the whole stream down?
It follows, kind of flows down to this.
No, it's down the boundary.
Oh, sorry, yes, it follows this boundary, and then that's straight along the cadastral boundary.
And the stream just follows south.
Follows south, yes. So have tried to follow a defensible boundary that council proposed.
Yeah, I mean, we'll probably try and have a look at it, but how much of a stream is it? Is it like a?
Oh, it's a water course.
Yeah, it's a freshwater stream.
Yes, it is. Yes.
Perennial stream.
It's got a spring.
Does it flow all year round?
Yes. Yes.
Thank you.
So again, a very quick summary of the 32AA assessment and the criteria, council's criteria, zoning criteria in my original evidence. The location is not subject to anything notable at all. It's not subject to mapped natural hazards, it has no heritage sites or areas, sites of significance, outstanding natural features or landscapes. In my opinion, rezoning location 1 will give effect to the PDP strategic direction. location 1 aligns with and will give effect to the proposed rural residential zone objectives and policies, and will give effect to the relevant MPSs, NESs and RPSs. And my conclusion in my detailed 32AA is that it is an efficient and effective option. And I do just note that the questioning around the quality of the stream and there's vegetation, and this is a beautiful location, and development provides very good opportunity to protect those types of natural features that are there, even if they are not mapped for protection. Subdivision often leads to protection of those features. Again, Ms. Shaw has covered this off nicely, so I'll very quickly just touch on that a detailed analysis of whether or not rezoning a location rural residential zone would give effect to the MPS HPL, and there's quite strict criteria in that about zoning land a rural lifestyle zone versus zoning land an urban zone. And I went down quite a rabbit hole into this when preparing my evidence.
You can't avoid that.
So in my opinion, because this has been proposed as a rural residential zone, it's a special purpose zone, and it is intended for future urban zoning, it is not listed in the NPSUD or the NPS HPL as a special purpose zone. I conclude on that basis that it would be appropriate to consider it under clause 634 of the NPS HPL, and that is the urban zoning optioning, and that's the optioning that applies to a tier 3 council.
So just to clarify that, the purposes of rezoning to a rural residential zone, you treat it as if it's rezoned to an urban zone.
In this instance, yes.
I think that's what the NPS requires you to do.
Mm-hmm.
Yeah. Thanks.
I'll just briefly touch on the housing and business development capacity assessment. I will leave Mr. Foy to go. It's his place to that in more detail, but it concludes that there is insufficient capacity for both residential land in the Kerikeri-Waipapa and wider Far North District area as a whole to meet the future demand. There is a shortfall of residential land at a district level in the next 3 years, and that will be persisted over the next 30 years. Again, this is Mr. Foy's assessment of the situation. And there is a shortage of detached housing in the Kerikeri-Waipapa area in a short term, and that will persist for 30 years. And therefore, that leads me to conclude that location 1 is the minimum necessary to provide the required development capacity. And the reason why this is sitting in the NPS HPL, and those are the tests that link you into clause 364.
Conjunctive, right? Yeah.
Turning to the NPSUD, so sure, you've heard a lot about this. Had a lot of discussion over the last few days. I've been popping in and out and listening to things. So just again highlight that it is council is obliged to provide at least sufficient development capacity. It can provide more. It can provide as much as it likes. There's nothing stopping it from doing that.
And this applies, and in your view, this applies to a rural zone. Because the rural residential zone, you know, we don't have nesting tables, but it sort of nests in the rural, it's in the rural chapter.
It's an interesting beast, isn't it? So it's been put, the council has chosen to put it in the rural chapter, but it leads you to a future urban.
Well, the New Zealand planning standards, national planning standards, sort of, that's the zone that allocates.
It's not in the national planning standards because it's a special purpose zone, so the council made it up.
But the rural residential zone. So, okay, but it's a rural zone. The question.
They've labelled it as a rural zone, yes.
So are you saying for the purposes of the NPSUD it is an
urban zone? It is contributing urban housing at the edge of the Kerikeri urban area.
And this has been a matter that we've been wrestling with since we're hearing C is what is the function of that zone? And obviously you've gone to its description and its objectives and policies.
Yes.
Sort of telling us sort of what and that's what it is. Yet, I mean, one of the things we're wrestling with, it seems to be it's a zone for all people. It's there for a rural purpose to provide, it's offsetting the loss of subdivision opportunities in the rural production zone. But it's also providing another form of urban housing under the, and our question is, can it be both? And if so, what are the consequences of it? And that's got issues related to and how you define and calculate capacity.
So I
And it seems to
understand.
me that, you know, sort of a lot of people are looking to that rural residential zone as an urban zone when it,
They
in some
want it.
contexts,
Yeah.
and as a rural zone in other contexts.
I agree. It's a tricky one, and it is trying to do all things to all
How we
people.
reconcile that?
Yeah. But my understanding of how the NPSUD and the calculation of capacity is it can be outside of urban zones, so it's a capacity requirement across the district, and that's where your HPA comes into it. And so, yeah.
It doesn't help that the HPL basically says it's a urban zone, but doing 3.6 sub-clause 4. And then, yeah, is there any guidance in the NPSUD as to where rural zones or rural lifestyle or rural residential zones fit? Are there any guidance in the NPSUD with regards to those types of zones?
I don't think so. Mr. Foy may have been able to comment on that, not to my knowledge. I have been in many hearings with the faced with this similar conversation of are we an urban environment, are we not? Is it across a district, is it not? And I think it's something that everyone reckons with. Mr. Foy, did you have any comments on that?
I mean, I think it fulfills the role of an urban zone just because of the type of housing, and it is housing on larger lots, so there are sort of rural elements preserved, I suppose. But yes, basically large lot urban development, in my opinion. I'm not sure specifically from the NPSUD how that would treat it, or the HPL, but because it's not in the planning standards, that doesn't offer us any help either. So yeah, I'm of little help, unfortunately. I'm sorry.
Thank you, Mr. Foy.
Where that gets us. Anyway, so I'm just letting you know that that's what we're wrestling with currently, and any assistance you can give us on how to resolve that, it would be helpful.
Yeah, the only thing that we can, Ms. Shaw's just drawn my attention to is that the description of the rural residential zone is in a location where an urban area may grow. So it's, again, it's, as you say, it's trying to do multiple things.
Yeah, it's a main, so it's not saying every rural residential zone will ultimately become urban. It may evolve into an urban zone, but it's a rural zone for now. Anyway, we're two national policy instruments that are sort of trying to do. We're just trying to work out where this zone fits under either.
So just the spatial plan has assumed some growth, and it is assumed more than what the business and housing and business development capacity, the HBA baseline has assumed. So again, I'll let Mr. Foy elaborate on that. It's absolutely his area. But I do highlight that the spatial plan, and you've had conversations about this many over the last few days, I'm sure, is a non-statutory document. And in my opinion, it does not constitute a future development strategy under the NPSUD. But if you were to conclude that it was, or you wanted to place some more emphasis on it under the NPSUD, the FDS is required to identify broad locations in which development can be provided. So it's not intended that that would be the finite line of where development or rezoning may go. And I'm concerned that the 42A has really latched on to the boundaries of the spatial plan without considering the merits of the rezoning requests.
You don't think the spatial plan broadly identifies locations for growth? I mean, that
No, I
sounds
don't.
like it's functional to me.
It has considered future growth options.
Does it come down to what
And
we
those
interpret?
options have drawn lines, and those lines have been applied by the reporting officers.
So that comes down to what we consider broad locations to me.
And again, highlighting that location when it's not greenfield. So just quickly summarising the transport effects. Oh, yes, switch over.
We're going to bring Leo, Mr. Helson, now, is it?
Oh, no, he'll do his after, but that's a slide for later.
So turning to locations 2 and 3. So when reviewing these locations and looking at it in more detail, and at the time, I didn't have a town centre zone to consider, and it seems to me that this was better suited to have a precinct, because I've put forward to you a precinct with some very simple provisions that look at the nature of these locations. And again, I've gone through the zoning criteria that was put forward, or the criteria from here. Minute 14, the council criteria, there's nothing special about these locations. In my opinion, they align generally with the MUS objectives with a few nuances, particularly with active pedestrian frontages and the like, just due to their locations. They give effect to the strategic direction and are consistent, giving effect to NPSs, NSs and the RPS. Again, section 32AA, it's been detailed in my evidence, concludes it's efficient and effective. So here, just this slide, I appreciate it's difficult to see up there. This is in Mr. Boyd's evidence. And it identifies all of the types of activities that are occurring in locations 2 and 3 now. Clearly non-residential, mix of all sorts of commercial activities happening in here. We've got office activities, we've got restaurants, we've got retail, everything under the sun. And the reporting planner has concluded that this location would be suitable, would fall under the rural production zone and the horticulture precinct. And to me, I look at these images and that's not productive. It's just not. And I look at the recommended changes to the horticulture precinct. These activities would be discretionary, non-compliant. There is avoidance, objectives and policies. An objective that has been recommended to manage and ensure its current and long-term protection and availability for horticultural activities by enabling and prioritising horticulture, farming and ancillary activities other than those activities that do not have a functional need to locate in the precinct. These would not fit a functional need to be in that precinct. There is an avoidance policy put forward that are incompatible with the purpose, to avoid land use that is incompatible with the purpose, function and character of the horticulture precinct. These activities would not be able to achieve that avoidance policy. So by saying that it's fine, there's some provisions in the plan and you can apply for consents for extensions or new activities to co-align and grow in these locations. They're not going to get through the test. Again, I've got a little summary of redwoods there for you. You've already heard about that this morning, so I won't elaborate too much. Yeah, I think I will skip to Derek because I'm moving too slowly. But again, the NPS and the HPL, in my opinion, have been met. The zoning would be consistent with the outcomes. And So just briefly, the recommended precinct provisions. So I took the mixed use zone because that was all that there was before me. I mean, clearly I don't think that a future town zone would fit in these locations. And it recognises the mix of activities and locations 2 and 3. I've recommended provisions that acknowledge the prominent road frontages of Kerikeri Road and State Highway 10, and therefore have not applied the pedestrian frontage requirements of the mixed use zone proposed by council, and added some more restrictions that would be better suited to these locations in terms of activity types, and based on the evidence of and instruction from Mr. Hills, I have put forward in the rebuttal a cumulative transfer effect rule that would manage potential cumulative effects on Kerikeri Road.
So I don't know if you want to ask questions of Ms McGrath now or hold those until after you've heard from Mr Hills and Mr Foy and come back to planning the questions at the end.
Yeah, well, just one quick question about your precinct provisions. I mean, were you intending to put a plan in the precinct?
Yes, there would have to be a plan.
Yeah, because I didn't see one, and obviously you referred to it as the agglomeration. The agglomeration of commercial activity on Kerikeri, and I'm thinking, oh, that's
apologies, it would have been helpful to.
That is the plan.
Yes,
yes. I think there is I think there are addresses.
We would just attach locations to it.
Yes, that was,
I would suggest, yeah, if you want to pursue a precinct of that land, you just a simple precinct plan.
Yes.
And can I just confirm that Mr. Otway's relief and your relief are, I just had a look at Mr. Otway's, I mean, he drew a big circle, but you're aligned in terms of the boundaries of the property.
Yes, I have seen that resource consent that he was referring to.
Yes. I mean, I put that, I don't know if you saw my questioning of Mr. Otway, and I put to him, you've got your resource consent for your medical centre, you know, you've got your cafe, you've got your garden centre, you've got any other commercial activities in the works. He said, no, this is what I want. And I said, well, these are all lawfully established, got consents, you're doing nicely with it. Why do you need to? Why do you want to? I'm sort of obliged to put that question to you. It was slightly unfair to get it to him because it was a bit of a technical question.
Yes.
And you know, he responded to me and said, I just want my land to reflect the activities that are on it. I suspect there's possibly a more nuanced argument than that, so I'm going to give you the opportunity to put that.
Before you do, I think there was an appeal. So Mr Otway's recent resource consent was appealed by the neighbours because it was granted. The hearing commissioner on that hearing, I acted on the appeal, wrote into the commissioner's decision that the operative and proposed rural production zoning was clearly mismatched with the activities on the site, which have been long established. There is no rural production, there is no potential for it in the future. So there was a comment in that, and it was a theme of that hearing. You're applying objectives and policies and rules from the rural production zone to a long established commercial activity. So he may have that in his mind as well as a recent gripe that he's had to go through for 2 or 3 years of applying provisions. Because I think his answer earlier today was, you know, that they're not, it's not rural production, and it never will be. So why should it be called that?
So we asked Mr. Otway for the resource consent, but it might help if you could furnish us with a copy of that decision.
Yes, that was Mr. Littlejohn's decision from memory. I'll send it to you.
I think it's true. It's quite, if they were to seek to change that resource consent, change the activities on the site, he may change. It may sell, and future owners have different aspirations. As I've highlighted, the rural production zone and horticulture precinct objectives and policies are so strong that they wouldn't get through the resource consent test. So it's dishonest zoning to identify as horticulture precinct or rural production.
So what you're seeking doesn't cut across anything that Mr Otway was seeking?
I had a question about the site itself, and it's on Kerikeri Road. This morning when we were walking here, there was a boy on a bike that we moved over for, And there was also the scooter, that was just between our accommodation and here. Did you have any comments about its proximity to the town centre and in terms of vibrant town centres and pedestrian links and those type of aspects for the site?
I will let Mr. Hill talk about the transport. I do also note though that there is a footpath running from Access Road. It's on one side of Kerikeri Road. So there is pedestrian connection. And obviously the more that you have activities occurring, the transport rules will...
Pedestrian connection's on the other side of the road, isn't it? Because
It's on the southern
I've
side.
walked up there a couple of times. But yeah, I know that there is a pathway, a footpath there, I think on the other side of the road.
Yeah, southern side of the road.
Yeah.
And that's wider than a standard footpath. Is that right? It's a shared path?
I wouldn't be able to answer that, I'm sorry.
I think the footpath then comes back, I think it goes along both sides of the road and then it's just one side of the road and then it comes back.
And I think it's dependent
I'll
on the
ask Mr. Harris
upgrades
that question.
from different developments that have
Yeah.
triggered.
Yeah, I think council's taking the opportunity to get a footpath in there when there's.
Mr. Hills is asking as well.
Yeah.
Yes, let me pass over to Mr. Hill.
Yes.
Do you want to just move the slides on because he's got the last two? Mr. Hills, you'll just have to holler at Ms. McGrath when you want her to change the slide for you.
Thank you. You can, good afternoon, Commissioners. I'm assuming you can hear me.
Yes, good afternoon, Mr. Hills.
Excellent. I'll answer that question that was just raised probably at the end. I've got two slides. Yes. So you've obviously got my rebuttal evidence in terms of the areas, and I've looked at particular areas 1 and 2, which are the two Kerikeri Road sites. So I'll just go through the first one, which is area 1, which is the rural residential one. It's in the slide in front of you. In terms of this site, in terms of the area, you've already heard it. It can accommodate an additional 26 additional allotments. Now, looking at the traffic generation associated with that sort of number of allotments, I describe that as very minor and it's unlikely to cause any noticeable impact or change in the operation of Kerikeri Road. So I had no concerns in regard to that change, I guess. So maybe turn to the next slide and I'll probably go to the end and then maybe ask questions. So if we can turn to the next slide, please. So the next slide.
Separate from, sorry, so he's actually a Kerikeri boy, so...
Yes, well, I can point that out if you like. Yes, Kerikeri is my hometown, or was, a number of years ago. So yes, I'm very aware of the area, I suppose, as I should have pointed out. So the next is the area 2, which is on Kerikeri Road, which we've talked about, where there's obviously a lot of, I suppose, which you've been talking about, which is, I guess, more commercial activity occurring. The district-wide rule, as you would know, has I suppose a trip generation threshold per lot included. And in terms of that, my point of view is I think there's around 17 existing lots there. Each lot on its own, again, from my opinion, looking at the level that triggers consent in regards to the transport rules, would not cause any noticeable effect on the surrounding network. However, I have identified in particular that I haven't done a full ITA on the area, that there is potential for cumulative effects relating to those triggers, and particularly if I suppose each lot then gets subdivided and subdivided again. So I have recommended, and it's in my evidence in terms of the calculations, but a trigger, I guess, in that precinct, which after 8,000 squares of commercials, that there would be a trigger to do, I suppose, a full ITA of the area. And probably one of the key things would be, in that regard, ITAs are pretty well known in terms of integrated transport assessments. But one of them actually relates, interestingly, one of the issues you would look at relates to the comment that was just discussed. The footpath is on it's actually a shared path. It's actually designated with signage as a shared path. It varies in width. which is interesting. And it's typically on the out to this side anyway, on the eastern side, and it does link in, which I think is one of the great reasons in terms of this. I suppose the site is quite well located and a little bit unusual in terms that along Kerikeri Road, even since I was a child, this area was always, this type of sort of development was already there. The footpaths have developed as the years have gone on to enable essentially what one of the commissioners just mentioned was cycling, walking, and scootering into Kerikeri from this area. So that probably summarises my evidence. I'm happy to answer questions now or at the end, as you wish.
Carry on.
No, that was my main question.
No more questions for you, Mr. Hills. Thank you very much.
Thank you.
I'm wondering, sir, Mr. Hills may wish to stick around, but he's been in the Environment Court for the last 2 days, and if we think it's unlikely that he'll have any burning interest in Mr. Foy's economic evidence, if Mr. Hills might be excused if he wished to do so.
Yeah, yes, we'll give you the discretion to exit stage left, Mr. Hills, if you wish.
Thank you all.
More than welcome to remain. Mr. McGrath, I just, before you move on, I did have another question for your precinct. Let me get it up here. Yeah, in your first sentence, well, in your first paragraph, you refer to State Highway 15.
Apologies.
I thought that'll end up,
Should be 10.
I'll end up in Megatappery.
Actually, that's where I love this program. I got it from. No,
Yeah, that should be 10, right?
The madness of drafting. Yes, it should be 10.
We're all,
My eagle eyes picked it up.
I did it?
No, not
Oh, not the actual precinct. My eagle eyes missed it. Picked it up in the slide.
Yes, you're quite right.
Oh, I get some eagle-eye bonus.
Apologies.
Thank you.
It was in the slide originally as well.
It's just in my mind, it's been playing uneasily in the NPSUD discussion we were having before about, is it urban, is it rural? I'm just looking at the definition of urban environment in the NPSUD, and it talks about an area being predominantly urban in character.
Yes.
And that's kind of what's in my mind. Is this urban in character, or is this
In
rural?
my opinion, it is urban in character.
How do you get to that conclusion? I mean, in my mind, it's like curbs and channels and street lights and what have you.
And lot sizes and curtilage and the density of built form.
I mean, what's the lot size that would become urban versus what would become rural? Because we've got the other zone next door, which is rural living, which is, potentially closer to urban than rural lifestyle. But what's the?
I understood rural living was a lifestyle. Sorry. So,
There is no rural living.
there is no,
It's rural
that was the
lifestyle.
operative zone. Sorry, that was the previous operative zone. So it jumped straight to general residential.
Yeah.
So I think the question being put to you is, have you considered in terms of your options, whether a rural lifestyle zone would apply?
No, I considered that. Yes, I turned my mind to it, but as that is proposed, it's an isolated lifestyle zone with larger lots. So these lots would be too small to fit within the expected character of that proposed zone. So I did consider it, yes.
Okay. Yeah, that's. Thank you.
Do we now move to Mr. Foy?
Yes, we do. And he has a summary
If they received that. So good afternoon, Mr. Foy, it's your turn. You have.
Good afternoon, sir. Thank you. Yes, I understand my my brief summary has been handed up already. I will just speak to that. I won't read it all out, but I'd just like to cover off my summary under the two main topic headings, I suppose, of the firstly the mixed use precinct that's been requested. I think that's the origins of that arise, and as we've heard, the large amount of non-rural and non-residential activity that exists in the two aggregations around the what I've called the Redwoods node and the Packhouse node. So those are locations 2 and 3, has been referred to today. So there are quite large aggregations of a wide range of commercial and other activities in those locations, and they become a bit difficult to manage in the proposed plan because of the lack of a hierarchy that's been established for commercial zones. So there being only initially the notified version of only the mixed use zone proposed. I think with previous hearings that it's likely that the town centre zone will apply. That provides some distinction from these smaller commercial nodes, and that's typical of urban environments where there are, especially as these urban these towns are growing, that there come the need to be more commercial provision than just a single central business district. And we've heard that commercial aggregations have existed on the side of the Packhouse and Redwoods nodes for some time, but there comes to be pressure where those grow in response to increased demand from the local community and from visitors. And I think both of those nodes are in good locations. They are reasonably close to the CBD and to Waipapa, respectively, although not close enough that they are right next door and form part of the contiguous commercial zones there. But I think the point with centres and commercial nodes is that they tend to not be located right next door to each other and are separated a little bit, because that they serve slightly different catchments and different roles, and they tend to locate in places where there is some locational benefit to the businesses that are going to be there. And the fact that there has been activity there for quite a long time, and especially in the case of the Redwoods, the Packhouse node, that actually the share of Kerikeri's employment that is in that node has increased over time. It shows an increasing importance of that zone, that node rather, and shows some revealed preference for businesses to be in that area. So there's obviously something going on that businesses like there. Location and proximity along Kerikeri Road is probably one of the main things that's attracting businesses in that location. And I suppose the businesses there have a fairly strong sort of attraction to sort of the tourist element around the Packhouse and Makana chocolates, etc. So there are a wide range of activities there, and I think it makes sense to recognise them as such. And the Urban Rezoning Requested, I think, does that well. And I say that the Urban Rezoning Requested by Ms Campbell Freer satisfies the requirements of clause 3.64 of the NPS HBL. There is a shortage, or there will be a shortage of commercial land supply arising in Kerikeri in the near future, and Mr McElroth's evidence agrees that that will be the case. There's already, as we know, quite a wide range of activities in the Redwoods and Packhouse nodes, and it's not practical or feasible in terms of clause 3.64b for those to be provided or shifted somewhere else. It's inevitable that they will remain in some form, and the fact that they've grown organically, even in the face of intended outcomes from the existing planning environment, because they're not zoned for there, there's been some considerable effort expended by landowners and tenants to establish in that location in terms of resource consents and etc. So I think formalising their existence and allowing for their efficient continued use so that they can make small incidental changes as of right. So I'm not completely up with the planning rules that would govern things such as signing and car parking, but making small incidental changes such as to those matters would be much better enabled with a some form of commercial zoning, such as the proposed mixed-use precinct on the site. So I say that clauses 3.64A and B are met, and then the economic benefits under 3.64C, I say that there will be the benefits of being economically efficient in the way that businesses in that area are able to operate. The very small economic costs, because the loss of the very small amount of rural land will have negligible impacts on rural productivity. There's very limited productive capacity there because the parcels are so small. There's such a large amount of non-rural activity in the area, and as Ms. Campbell-Freer said, there are quite a few constraints in place that control how rural functions such as spraying can be undertaken already. So turning to rural residential zoning, I also say that the three limbs of 3.64 of the HPL are met in regard to the proposed rural residential rezoning that has been requested, because there is a shortage of development capacity for detached residential dwellings in Kerikeri now, and additional supply will be required to meet that demand. I note that the PDP R zoning scenario that is aligned with the spatial plan would, if accepted in its entirety, provide some of that additional supply, although even with that additional supply and with the assumptions about increased intensification of dwelling use, there would still be a shortfall arising by the late 2040s, as identified by Mr. McElroth. If that growth, and that was with growth occurring at the level that's lower than what's assumed in the spatial plan, which adopts a higher level for conservative reasons. If growth is at that higher spatial plan sort of level, residential supply would be exhausted much earlier than 2048. And so the proposed rural residential area that Ms. Campbell-Freer seeks would alleviate a small part of that large shortfall of capacity, and so I say is consistent with 3.64A. It's also consistent with B because the fragmented nature of parcels in this area and the number of dwellings already here indicate that the horse is already bolted to a large extent, and that the area is not suited to rural production. And Ms. McGrath's evidence sets out the practicable and feasible options for providing required development capacity, and concludes that while there are options for providing additional residential activity elsewhere, they each have their own limitations, and none are more practicable or feasible than the area proposed by Ms. Campbell-Freer. Similarly, the benefits outweigh the costs because of the very limited loss of productive rural land, and the small amount of land that might be lost, and the limited productive yield of that land means that the benefits of the requested rural residential zoning will exceed the costs. So I maintain the conclusion reached in my primary evidence that the creation of a mixed-use precinct and an expanded area of rural residential zone is appropriate and necessary, and both are logical and appropriate places in which to provide some of the shortfall of capacity that's identified in the housing business capacity assessment. The zones in the precinct are consistent with the requirements in the NPS HPL. So that's my summary. Happy to take any questions.
Yeah, I'll start off, Mr. Floyd. I don't know if you were hearing the questions I put to Ms. McGrath before about the rural residential zone sort of being all things to everybody. It's a rural zone, it's also treated as an urban zone. The NPS HPL sort of says you're not a general rural or a rural production zone, you're an urban zone, so you use that. But it is in the plan as a rural zone, and it's also part of the rural strategy for providing housing within the rural zoning framework. One of the things we're wrestling with is, for the purposes of capacity, we treat it as a rural zone or as an urban zone. I think it looks as if your assessment is treated more as an urban zone. Is that correct?
Yes, I mean, in the definitions in the NPS HPL, there's a definition of urban, and it doesn't include rural residential zone specifically, I guess because it's a bespoke zone, and the description in the HPL probably refer to the national planning standards more, but urban in the NPS HPL includes low density residential, general residential, medium density residential, large lot residential, and high density residential. There are no residential zones. Sorry, I see this rural residential zone as similar to some of those. So the large lot and the large lot residential zone. It doesn't. The rural residential zone proposed. I think that the functions of it would not be rural in nature. That's not intended to be a productive rural zone. I don't think there would be a lot of that sort of rural activity that one would typically associate with rural zones going on there. I think it would be a primarily residential focused zone, houses and bits of land around them, rather than barns and animals. So yeah, I would associate it more with an urban zoning, yes.
And so obviously you're familiar with the spatial plan, and it's got a objective of trying to encourage intensification, and then you've got the mixed, we've got the new town centre zone, the mixed medium density residential zone, obviously trying to facilitate that. It's been sort of put to us that intensification is hard. It's quite hard to achieve. You're looking at redeveloping existing sites, potentially demolishing buildings and building more intensive dwellings. My question to you is, if we're going to be treating the rural residential zone as a default urban zone, which can be established without articulation, I would think that we sort of look at the minimum lot size for the rural residential zone as the smallest you can get without having to connect to articulated services. I know that's not the definition, but that's sort of how I see it. When you look at the flow of investment dollars, and if we take that principle that rural residential is relatively easy and intensification is a little bit harder, is there a risk that we may overzone the rural residential zone and not encourage investment to achieve intensification? In other words, if it's always easier to go down the rural residential route, well, is that where the investment dollars will follow the easiest path to a return?
I don't think so. Well, I mean, to some extent, yes, the dollars will follow the easiest path, but I think there's a time and a place for both types of zone, and around the urban fringe is the place for the less dense residential topologies, and nearer the centre is the place for the more dense types, and there has been acknowledged to be a demand for both, and the the popularity of rural residential zones, with that sort of rural-ish type of residential activity in Kerikeri has been recognised, and the Section 32 report refers to that. So it surveyed local real estate professionals in Kerikeri and found ongoing demand for rural residential sites. And I think the natural way of things is that as the town grows and must necessarily push out to some extent, because I don't think that all growth can be achieved just through sort of infill and intensification. There must necessarily be some expansion of the urban area. The appropriate way to achieve that is less dense cadastral sort of formats around the fringe of the town, and over time as those get subsumed and the fringe pushes further out, there will come to be pressure on those to be cut up and intensification achieved in that way. And think of it as a curve with the densest formats near the town centre, and there will over time come to be increasing demand from the market and acceptance from landowners that those increased densities are actually viable in Kerikeri, and that may be a slower, maybe more slowly achieved than in larger urban economies, but that increased intensification, I'm sure, will come to be more accepted in Kerikeri at some point, but maybe a bit slowly.
Yeah, I mean, we've yet to, I mean, we've received a lot of economic evidence in this hearing. The previous one, yourself, Mr. Thompson, and Mr. McElroy. We have a number of different methodologies and different conclusions as to there's a massive shortfall of rural residential. We've got plenty of, we've got an oversupply, and we've got to wrestle our way through it and come up with a finding, given that none of us are economists. But it seems to us that there needs to be quite a delicate balance where this concept of oversupply potentially, and that is, I mean, if intensification is to be an objective of plan, and there is a strategic objective that talks about compact urban, then I think it follows that if the easiest path for investment dollars is to go to rural residential, that you actually have to run out of it before your intensification really takes off. Or is that a bit too simplistic?
I think it is a bit simplistic. I think there is demand from various market segments for different housing typologies, and there's an increasing acceptance of apartment typologies. So, you know, that's observed first in the larger economy, so Auckland and Christchurch, and then it sort of trickles down, and that will come to be a more accepted sort of way of living in apartments and terrace housing, because people will come to get more accustomed to living in smaller properties with not the move away from the quarter acre section with the vegetable garden and a big back lawn, and people over time do come to be more accepting of apartment sort of living, and that's a generational change almost. And I think there is that demand that exists in the market, and that will increase over time, and that will be a large part of what spurs intensification. And intensification shouldn't be just spurred by a shortage of development land anywhere, because that's quite an inefficient outcome, and is not really a very effective way of being responsive to demand. But there's room for both approaches in the market. I think they're complementary.
No, thank you. Okay, looks like that's it, Mr. Boyd. So thank you.
Very good, thank you, sir.
In response to that last question, sir, I think also the NPSUD, which of course is seen as the holy grail for urban intensification, also talks about choice and a range of typologies, and so there is quite, even in the NPSUD, there's quite a focus on enabling the market to respond, and I think that KFO probably covered that off with you in quite some detail yesterday.
Yeah, yes, but although we had some pretty clear economic evidence, which is that the choice was literally lot size, but we're talking about detached dwellings, and it was a mix of lot sizes. It seemed to me that was driving the choice. Bit of a mismatch between the urban designers' expectations and what Mr. Thompson's expectations were. It seems to me that, yeah, I think the NPSUD is probably talking about some of the more intensive type of options, and that's where I think the spatial plan was trying to enable. What we've just been wrestling with is how you have what part supply place in getting those sorts of housing choices. I mean, and there's a whole lot of demand factors as well, which I think is what Mr. Foy was just saying to me now. Don't just focus on supply, there's also demand factors. There's a mix of both. And Mr. McElroy did introduce this concept of oversupply, and I've been wrestling with what that means in terms of Kerikeri, particularly in the rural residential. But all these answers are quite helpful.
I think yesterday, one of the things that came through for me for the CAPO presentation, which has been familiar from lots of other work I've done as well, is that intensification is not something that is held in a sense, because as you've indicated, there are barriers to redevelopment, but also a district plan is an enabling document, and people will choose when, within that, when and how and where they want to respond. So you can zone as much land as you like for apartments, if they're, but people have to be willing and ready to bring a development forward. And so all of the estimates of capacity and supply and delivery are all highly dependent on actual response from the market, people who are willing to bring forward a development. And then that development is successful and it sells, and so someone else is willing to do one. So in any of them, what we're talking about, particularly when we're talking about oversupply, we're talking of, I would say that is enabling, but that's not the same as take up. There is often quite a wide gap between them.
Yeah, I think those are all fair comments. The other thing that comes through with the NPSA field are efficient transportation networks, and we're trying to wrestle what that means in Kerikeri-Waipapa context as well. So, and of course that's a pretty clear directive that isn't about a market thing. This is like about an outcome that they think is a part of the well-functioning urban environment. Still, do you have anything else to add, or do we think that's?
Thank you. Thank you for your time.
Well, thank you very much. I think we've done really well. We'll have a chat about. We'll certainly have a break now. But you're welcome to stick around, and we'll probably have some lunch now. Partake of Kai here. So thank you very much for your presentation. Thank you very much, everyone online who's still here. We can have a chat about lunch. And
there's a few things, Mr. Chair.
You want some clarification questions?
No, specific between us. I don't want to necessarily concern the panel at this stage, but just want to flag that we are having some problems contacting Mr. Hensley. And I know that you want to have the opportunity to have that discussion, so we're working on that. I understand he's in a workshop with the CCO today. We are working. We're doing our best to do that. However, if we can't do that, I think there are some solutions that allow conversational questions to be asked of Mr. Hensley. Because I don't want to.
We might arrange maybe a Teams meeting later.
Correct. I don't want to prevent you from having an opportunity. Okay. I just wanted to flag it now. And in terms of time frame, we've obviously been doing quite a lot of work through this process to put together probably a reasonable right of reply, but we still perhaps need a bit of time to coordinate the octopus. So I think
we've got nothing else planned today. So, +3? Yeah, I was going to say, I think you obviously need a bit of time to coordinate and discuss, but you also need a quick break, and you have some food. So, yeah, 3 is when you want to reconvene. Do you want to make it 5:30?
I think we'll pass this one.
Yeah. We make it 5:30, and I guess we let the time at the end of the day.
Okay. Yes, make it 5:30. We are adjourned until 5:30. That's a good connection.
Okay, so everyone online, it's 3:30, we're coming back, stopping the recording.
And then force break. Well, yes, when this one's ready to go, we'll get started early, right?
Yeah.